Hey, Paul Rabelais here. Wanted to talk about a situation that I dealt with recently, and happens a lot when couples get divorced. I was talking to a woman recently. She came into the office, and I think it was her mother suggested that she come in, and she had three kids, and she'd been divorced. I don't know why they got divorced. Doesn't really matter. But her ex-husband had recently married another woman, and that woman had several kids, and so now the ex-husband had some stepchildren, and relationships and were a little sketchy. So, I could tell my client, the woman, nice lady, wonderful mother, just marriage didn't work out. So her biggest concern, as most mothers is, was protecting her children, and in this case, protecting the inheritance that one day she will leave her children. So, we talked about some of those things that happen when a divorced person leaves things to minor children if things aren't set up the right way. So what would happen? And of course, she's young and she was busy and had no legal program in place. So we talked for a minute about what would happen if she passed away and nothing was in place for her children. Now things would go to her children, but it would be a mess in the courts because the first thing that would have to happen, all of her accounts would be frozen. Nobody would pay anything. Kids were minors and they were beneficiaries on her retirement plan, and since they're minors, the company's not going to pay anything to a minor. So the first thing that would happen if she had no plans was that a court would have to pick a guardian, and the court would likely pick the father. And so then court orders would be issued after some lengthy proceedings, designating that the father was the guardian of the minor children. So those court orders would have to be issued to the life insurance companies and the financial plan where the retirement account is held, to order those people to transfer the assets to the father so that he could manage it while the children were minors. So that would be in what's called a tutorship proceeding. And if the father wanted or needed to spend some of the money on the children for their education, their living expenses, or whatever, the father would have to get court approval to do it. The father would have complete control over the money, so kind of no telling what the father might do with those funds with that access to it. He has a new wife with stepchildren, and there's concern about influence there. So that would take place, and there'd be a lot of expense and a lot of difficulties while the children were minors, and the father was the court-appointed guardian of the money and would have to get court approval to spend it for education or tuition or other things. And then, when those minor children turn 18 on their 18th birthday, then because mom had no plans in place, the father would be required to turn over any funds to the 18-year-old on their 18th birthday. A lot of parents have concern about, when my child is 18, they're not going to be able to handle, a large chunk of money, sometimes hundreds of thousands of dollars, sometimes more. So we fixed all that. And now single mom, will have a program in place, a legal program in place, so that if she were to pass away while the children are still young, under 25, then her good friend would be in a position to manage all of those funds on behalf of the three children. And let's say the woman's name is Jane Doe, our client. So we're going to set up the Jane Doe Children's Trust with friend as trustee. And so that trust will be designated as the beneficiary of the retirement accounts, as the beneficiary of the life insurance, and the will that she has, anything that she has in her name when she dies, her home, her bank accounts will go into that children's trust. And while that father may have parental rights to raise the children, he won't have rights to go access all of the money that she's leaving her children. Her trusted friend will be that trustee in charge of handling the money for the children, and they won't get it dumped in their lap when they're 18. The friend is going to continue managing the money until the children are 25, use it for their education, other needs that they have. And sure, if the father needs money for the children, he can go to that trustee, and if there are legitimate needs, then the trustee can certainly pay for or authorize those expenses. So gave this woman a lot of peace of mind knowing that, you know, what she's been working decades for will wind up going for her children, and it won't go to some other third party such as the stepchildren of her ex-husband. So took care of all the other stuff she was concerned about as well. You know, if she becomes incapacitated, she wants certain people to be able to make her financial and medical decisions. She wanted to make that end-of-life living will decision about life support machines. We're getting all that documented. So she felt like she had felt better already just knowing that we had the conversation and things that were in the process of getting done. So, you know, if you're a single parent and you don't have the greatest relationship with your ex-spouse, or just simply if you don't want your ex-spouse managing the inheritance of your children, then you need to put some things in motion to make sure you get all that straight, have the right people in charge at the right time, and get all of it straight. So fairly easy to do. Just got to take that first step. Have a great day.